Hello, everyone. This is Tom Fox back for another episode. And I'm absolutely thrilled today to have Eric Morehead with us. Eric is the Director of Advisory Services at LRN, and as you will shortly learn, worked on the U.S. Sentencing Commission. So, Eric, first of all, welcome to the podcast.
Thanks, Tom. Happy to be here.
Eric, the reason I was so excited to visit with you is, as I mentioned in the introduction, your work on the U.S. Sentencing Commission. So could you tell us a little bit about your professional work with the U.S. Sentencing Commission, what it is, and what its role is?
Sure. I started out as a criminal defense attorney in Houston back in the 90s. And then in 2007, I moved to Washington, D.C. and took up a role as an Assistant General Counsel at the U.S. Sentencing Commission. The Sentencing Commission is an independent commission with 9 members of the commission. Sort of most people are more familiar with the SEC, the Securities and Exchange Commission, but it's a similar makeup. It's an independent federal body. 7 of those commissioners are voting commissioners, and they're appointed by the president. By statute, it's supposed to be a bipartisan commission. Usually there's 4 Republicans and 3 Democrats during a Republican administration, and 4 Democrats and 3 Republicans during a Democratic administration. Although the composition of the commission varies from year to year and term to term. The terms are 3-year terms, and they're staggered. The commission has, in its history, gone through periods when they haven't had a voting quorum. That last time that happened was during the previous Trump administration. And so while the commission still conducted some of its work, which I'll explain in a second, some of its activities, it wasn't able to promulgate new rules or create or amend the sentencing guidelines that many of us in compliance are already at least familiar with, Chapter 8 of the sentencing guidelines. And there is a danger that might happen again in the next few years. The current composition, there are 5 voting members left, and one of the remaining members' term expires next year. So they'll still have a quorum. They'll still have 4 members. But if somebody retires or gets hit by a bus, it's possible that the Sentencing Commission might be in the same boat they were during the last Trump administration in the 2016 to 2020 when they weren't able to promulgate rules. So what does the commission do? The commission was established in 1984. The Sentencing Reform Act was a bipartisan, big criminal legislation that went through Congress and the Senate in 1984. The sponsors included people like Ted Kennedy and Strom Thurmond. The thing that got these divergent personalities together was a disparity in federal sentencing in criminal cases across the United States, which had been accruing over the years. What I mean by that is if you were charged with, say, wire fraud in the District of Massachusetts, and a similar defendant was charged with the same crime in the Southern District of Texas, they might get wildly different sentences from the sentencing judge. And the impetus from both sides of the aisle was to try to get a reasonable sentence out of both judges that were seen to be too lenient and judges that were seen to be too harsh. So we have some consistency and some parity for federal sentencing for similarly situated defendants across the board. Basically, what the sentencing guidelines do is they take a look at the individual, so look at criminal history, background, and the specifics of the offense, and then try to come to mathematically a range for a criminal sentence based on the conduct. So for instance, in a fraud case, what was the dollar amount of the fraud would be a consideration. And then there also could be mitigating factors, like there was something involved in their background that is a mitigating factor that perhaps brings the sentencing calculation down. In 1984, the statute passed. In 1991, the original organizational sentencing guidelines came into effect. When the sentencing guidelines were first promulgated, they primarily focused on individuals, people charged with guns, drugs, immigration crime, which makes up most of the federal docket today and has for many years. But there was, as part of the statute, there was an understanding that there would be sentencing guidelines for organizations, for companies and other organizations that were charged with criminal offenses in federal court. So the sentencing guidelines for organizations came out in 1991. And how compliance comes into this and why we're interested in the sentencing guidelines is you can't put an organization in jail. You can fine an organization, but what else can you do? And what the Sentencing Commission in 1991 came to the conclusion that an important part of for lack of a better term, putting an organization on probation was encouraging better compliance so that the organization wouldn't reoffend, hopefully, in the future, or would have less likelihood of doing that. And so that's where the sentencing guideline standards for an effective program came from. It's all part of helping judges put together a probation plan, if you will, for organizations that are being sentenced in federal court.
So could you walk us through the process internally, either for creation under the sentencing guidelines or amendment? Is it staff develops proposals, they're sent to the commission, there's a period of comment? How does that process work, Eric?
Yeah, so there are a couple of initiating factors as to whether there might be potential changes to the sentencing guidelines. And really there's two groups. One is if there are changes to federal statutes. So a new criminal offense is created, or Congress makes changes to federal criminal law that necessitate looking at the punishments for those offenses. So that's one way that potential change to the sentencing guidelines could be teed up, is that there's been a change in federal law. Another is either a member of the public or a member of the commission themselves, one of the 7 members, might want to examine some area of potential reform in the sentencing guideline standards. However that happens, whether there's a change in law, there will be a set of priorities that will be put forward, and this happens every year. There's a cycle. Starting in June, summertime, these ideas will start percolating, if you will, and the commission itself has a retreat, usually sometime in the summer, where they'll start considering what their priorities might be for the coming year. Say June, July, the ideas start to come together. And this also, again, might be based on public comment or comment from an interested group like the SCCE or some other membership organization, or the Chamber of Commerce, who knows, has come forward and said, hey, Sentencing Commission, you need to take a look at this particular issue. In August, they'll, in the Federal Register, publish their initial priorities. That's, again, to solicit public comment and to gather up any information that might be necessary for them to either withhold making a change or making a change to the sentencing guidelines. Also, staff internally will be assigned to this. Internally, the Sentencing Commission has another role, which is to gather all the sentencing data from all the individuals and organizations that are sentenced every year. So if you go to ussc.gov, you can not only see the sentencing guidelines themselves, but you can also see a lot of data about both individuals and organizations that have been sentenced over the years. So there's a data gathering component of the organization where all of the district courts all around the country will send sentencing data to the commission. They'll gather that data, put it in their database. They often write reports. So not every year, but on an annual basis, there will be a handful of reports looking at particular sentencing issues. So they have this social science and data gathering aspect of the organization as well. A typical team that might be looking at, staff team that might be looking at an amendment might include a social scientist, probably a lawyer from the General Counsel's office. And then also there's a sentencing practice and training group that's made up of former probation officers and some lawyers as well. You might get somebody from that practice group also involved. And so they'll take a look at the proposed priority, say, to change an existing guideline or add something new. In September to December, they're going through that process. There will be potential also to have public hearings. That doesn't always happen, but on particular issues, but oftentimes if they want to solicit opinion. For example, in 2010, when I was the staff chair on the last significant amendment to Chapter 8 of the Sentencing Guidelines, we had a public hearing where we invited SCCE and other interested members of the public to comment on some proposed changes to Chapter 8 that would have affected the compliance guidance in the Sentencing Guidelines. Then proposed amendments are published in January. Those get reviewed and revised during where we are now in February, March. And then in April, there's a vote. If that proposed amendment makes it to the final docket, then it'll go in front of the commission. The commission will up-down vote as to whether to make that amendment to the sentencing guidelines. And then it goes to Congress, to the to the Speaker of the House and to the President pro tempore of the Senate. And we actually physically, when I was there, when you're a newbie, you actually physically take the proposed amendments across the way to the Capitol and put it and take it to the office of the Speaker of the House. And the Congress has 90 days to take action if they disagree with what the Sentencing Commission is proposing, the changes they're proposing to make. But if they don't, the guidelines become law on November 1st. And then the whole process starts over again in late December. So every year there's an amendment cycle. As I said, if they don't have a quorum, in years they don't have a quorum, then there won't be any changes because there's not a voting quorum. They do still have one. And so there's potential that, this May there might be a vote to make some adjustments or changes. I don't know if this is still true, but for years and years, there were only, I believe, 2 occasions when Congress did not just unilaterally accept the changes that the commission had suggested. So it becomes law, and the sentencing guidelines are binding. There was a famous case a few years back, the Booker case in the Supreme Court, that it used to be that the sentencing guidelines were mandatory. So judges, except in very rare instances, had to follow the sentencing guidelines when sentencing individuals. Now they are not mandatory, but they have to be considered, and the judge has to, if they impose a sentence outside the guidelines, they have to give reasoning why they do. So they're not the dictates they were back in the 90s and early 2000s, but still considered in every criminal case. And the number of criminal cases every year varies, but it's usually between 60 and 70,000 individuals and about 100 to 200 organizational cases. And so the sentencing guidelines get applied. And as you can tell, it's a standardized process. It's a process that the public has it's a transparent process where there's public hearings. Everything gets published in the Federal Register. So everybody has an opportunity to weigh in on it. The Department of Justice has a non-voting member of the commission who's always sitting with the commissioners. So the Department of Justice always has their opportunity to weigh in on any changes to the sentencing guidelines, as do any interested parties of the public. And I guess the one big difference between this and policy at the Department of Justice is that there is a process, and by statute, the Sentencing Commission has the authority to make these changes.
Eric, the reason I ask you to go into that detail is I want people to, one, understand it. And certainly you and I have never had the chance for you to fully explain that on a podcast, and that's on me, not on you. But number 2 is there has been some people who've suggested after the administration's suspension of FCPA investigation and enforcement that the evaluation of corporate compliance programs that have been in the public domain since 2017 be withdrawn. There have been further suggestions that the FCPA Resource Guide, first edition, 2012, and the second edition, 2020, should also be withdrawn, although those are mandated by the law itself. But there's a requirement for a compliance program in the sentencing guidelines.
Yes.
And if not the first, one of the first things you should learn about FCPA enforcement are the sentencing guidelines and the steps the sentencing guideline lays out for an effective compliance program. So I really wanted to really explore that as a basis for compliance professionals going forward with some guidance. And I'm going to ask you a basic question, but I think I know the answer to it. But can we still look to the sentencing guidelines for an effective compliance program for at least a basis of our compliance programs going forward?
Yes, because it's the most consistent since 1991, and they don't change that much. As I said, I was there in 2010, and the most significant recent change. There are some minor changes, some minor amendments that do happen to conform, change some citations and things like that. But actual substantive changes to the guidelines don't happen that frequently. Part of that is just frankly. Most of the oxygen at the Sentencing Commission is around individual sentencing because you have 60 to 70,000 living, breathing humans who find themselves in front of a federal district court judge every year being sentenced. And so that takes priority over the 100 to 200 on average organizational cases that end up in front of the federal judge. Because as we all know, most prosecutions, most regulatory actions against organizations end up being settled and don't end up with a plea or a guilty verdict after a trial. That's pretty rare. So the guidelines have an impact that goes well beyond that 100 to 200 organizations. In fact, I've often made the argument that I think the sentencing guidelines has a bigger impact on the larger group of us here in the United States and around the world. The bigger impact of the sentencing guidelines is because of Chapter 8, because of the organizational sentencing guidelines and the guidance for an effective program, because that touches every organization. So even you don't have to be facing criminal sanction to adopt the standards, the hallmarks of the sentencing guidelines that make up what an effective program looks like. And that's not going to go away overnight. Now, we live in strange times, and we can't rule out the fact that Congress might change the law. I think it's unlikely that they would get to the point that they would mess with the Sentencing Reform Act. There seems to be a lot of other priorities that are more top of mind. And honestly, Congress is not taking much action at all right now and hasn't for years. What can happen is what we're already seeing happen is a lot of changes with executive power. And the Department of Justice is the thing that has always concerned me about the fraud section memo. With the last Trump administration, the Deputy Attorney General at the time suggested that all of the memoranda were going to go away because he felt at the time that any kind of guidance to prosecutors ought to be in the U.S. Attorney's Manual, and that anything that was necessary for prosecutors to abide by needed to be in the manual. So there was talk that the memo might be transformed into part of the U.S. Attorney's Manual, which might have saved it if it does get rescinded here in the near future. But it would not surprise me one bit if we wake up tomorrow and we go to the website and refresh that page and that memo is gone. Because all it takes is the Assistant Attorney General in charge of the criminal division to say, pull it, and it's gone. Because it's a departmental policy for prosecutors. It has absolutely no force of law. Now, we've followed it and we've paid attention to it because we want to make sure that our organizations are aware of the risks from those that are enforcing the regulations. But those enforcement priorities have changed, as the executive order on the FCPA has shown us very clearly. So it wouldn't surprise me one bit if that memo, and also some of the other memos that have to do with charging individuals in corporate crime, some of these other memos that have been promulgated in the last few years also go away.
What kind of questions maybe are you fielding right now? Because I'm sure your text, phone, and email has blown up as much as mine has, particularly given your role at LRN. Really, how are you guys responding at this point?
Yeah, I think one of the bigger issues, or bigger two items, come up quite a bit in the compliance context. One is the attack on DEI that has come through in several of the executive orders and a lot of the movement in the individual regulatory agencies. I think particularly for organizations that are government contractors, they have real concerns about their internal DEI policies and making sure they conform to the new expectations that are voiced in the executive orders that came out. But also those executive orders mention specifically private organizations, and that the Department of Justice and other agencies are supposed to investigate DEI policies for private organizations, even if they're not government contractors. So I think DEI is probably the one that has been most discussed, because it is the executive orders are very explicit. It's a 180-degree turn from what federal government policy was. It's also in conflict with other federal regulations and state regulations, like in California, for example. So that's a real thorny issue for organizations right now to untangle. Is number one, what's our stated DEI policy going to be? Does it conform with the expectations there? And then the second one is one we already mentioned, which is the pause, as it's being called, on FCPA enforcement, because Trump obviously doesn't have the authority to rescind the statute. The Foreign Corrupt Practices Act, as enacted in 1977, still exists. But now it's not going to be enforced. At least I think it's 90-day pause, and then there's supposed to be an evaluation by the either 90 or 6 months, I can't recall, and then a reevaluation by the Attorney General as to enforcement. I think that one thing that what we've been saying, and I think what a lot of people in compliance have been saying to those that think this might be a free pass to go out and bribe everyone, is if you operate internationally, which most organizations that have high risk in anti-corruption and anti-bribery do, there are several other very impactful international laws, including the UK Bribery Act, that are still being enforced and may, who knows, may take this opportunity to ramp up enforcement because there's a vacuum, at least temporarily, in the United States. The other thing to keep in mind is the FCPA has a 5-year statute of limitations. The current administration might be assuming that this pause may or may not be permanent, but it may not be. It may be rescinded in 6 months, or it may be rescinded in 4 years. We don't know. Behavior that is, the FCPA is still the law of the land. It's still a violation of federal law to bribe foreign government officials. What this executive order has done is paused enforcement of it. So I think most organizations because most organizations are risk averse, are not making any massive changes to their anti-corruption policies and procedures now. I think the biggest effect that this is going to have is on the FCPA defense bar in the near term. Hey, Tom. Tom, sorry. I think you're on mute.
Eric, I think that's a good point for us to end this episode. But before we leave, I wanted to ask you if our listeners wanted to connect with you, find out more about your services at LRN or more about LRN, what would be the best place or places for them to go?
Sure, they can come to our website at lrn.com, and my specific email address is Eric, ERIC, Moorhead, MOREHEAD, at lrn.com. Happy to entertain questions, particularly around compliance on these issues. As you say, we're getting a lot of clients that are coming to us now because of the uncertainty of these times, and I certainly understand it. But I am glad that we're talking about the sentencing guidelines. Always, as anybody who's watched this now knows, I am a homer for the U.S. sentencing guidelines, and in particular organizational sentencing guidelines. I don't believe they're going to go anywhere anytime soon. I think that those standards that our programs are based on, and one thing I should also mention before, those memos that might disappear tomorrow, if you look at the footnotes, cite the sentencing guidelines. So all the detail that's in the sentencing the memo from the Department of Justice might go away, but the bedrock expectations for compliance are not going anywhere.
Eric, I wanted to thank you, and I look forward to continuing this conversation.
Thanks, Tom.